Friend, how are you? I'm Advocate Gaurav Kumar Gupta. I'm Chartered Accountant and MBA Finance and PhD holder. My project है डेरिवेटिव मार्केट फ्यूचर ट्रेंड एनालिसिस। आज जो हम एक केस स्टडी के बारे में जिक्र कर रहे हैं, एक केस स्टडी को एक्सप्लेन कर रहे हैं। बिलकर सिंह वर्सेस जगदीश कुमार का जो केस है 2005 का STPL 4340 सुप्रीम कोर्ट का, AIR 2005 सुप्रीम कोर्ट 1567 2005 186 का सुप्रीम कोर्ट ऑफ इंडिया। एन संतोष हेज एंड PK बाल स्वामी बलकर सिंह एपिलांट थे और वर्सेज जगदीश कुमार एंड अदर्स रिस्पोंडेंट थे। क्रिमिनल अपील नंबर 964 ऑफ 2002 विथ नंबर 334 ऑफ 2005 डिसाइड हुआ था। ये 22/2/2005 का यह डिसाइड किया गया था केस। इसमें कहा गया था क्रिमिनल प्रोसीजर कोड 1973 सेक्शन 482 एंड 321 का यह सेक्शन है। श्री ध्रुव मेहता लर्न काउंसिल appearing for the respondent accused in criminal appeal number 964/02 submitted whether the complaint filed by the appellant is motivated by collateral consideration. The respondent accused had already made a complaint in this regard. It is only after making proper inquiry and seeking proper legal advice, the government had decided to withdraw the case hence filing of an application under section 321 before the magistrate and order thereon being only a formality. The High Court was justified in passing the impugned order based on the statement made by the learned counsel for the state. He also submitted that if the High Court only had gone into the merits of the complaint, a plain reading of the said complaint could have convenienced the High Court that there was absolutely no case made out to pursue the said complaint hence. The petitioner before the High Court was entitled to the quashing of the complaint on merit also. He also submitted that presuming for argument sake that the appellant has been able to point out some error in the judgment of the High Court. Even then, this court ipso facto would not interfere with the erroneous order of the High Court because exercise of power under Article 136 is discretionary. It is only in case when the appellant is able to show exceptional circumstances exist in his case that non-interference would cause grave injustice. The alone this court could exercise its power under Article 136 of the Constitution. For this proposition, he relied on a decision of this court in Tharekutun by LRS v. Salam bin Muhammad. The learned counsel tried to point out the complaint in question was of the year 1998 and there has been no progress before the trial court, and assuming that the High Court is technically wrong in causing the complaint based on the submission of the learned advocate for the state, no injustice would be caused to the appellant. In the fact of present case, therefore, on the basis of the decision in Theraka Khatun by LRS Supra, we should refuse to exercise our discretion vested under Article 136 of the Constitution Though we are in our agreement with the ratio laid down by this court in Thara Khatun, we do not think the fact of this case would pursue us to refuse relief sought for by the appellant as stated above. What is pending before the High Court was a causing petition filed under Section 482 of the Code, wherein the scope of interference the High Court is quite restricted in such a petition. In our opinion, accepting a statement made by the Council for the State High Court could not have quashed the petition slowly on the ground. It could only have quashed the petition if it come to the conclusion that the complaint of the appellant did not make out of travel case against the petitioner before the decisions of the government to withdrawn the prosecution is an irrelevant ground ground so far as ground so far as High Court is concerned to allow a petition for quashing. It is rather surprising why further directions were issued by the High Court to the police and the magistrate not to prosecute the petitioner once is quashed the complaint. The direction issue in the impugned order by the High Court, in our opinion, is wholly without jurisdictions, even under Section 482 of the Code. The High Court ought to have noticed the fact that, but for the grant of a stay order, there was a possibility of the trial court even framing charges against the respondent accused as for back as on 25th October 2000 when the case was listed for the said purpose, in which event there could have been room for argument that even a Section 321 petition would not be maintainable. Notice this error in the judgment of the High Court. Sri Dhruv Mehta, Learned Counsel, submitted that in the interest of justice was should remand the matter back to the High Court to consider the causing petition on merit, since according to him the complaint did not make out any tribal case at all. We do not think that we do not think that this prayer can be granted, since we have come to the conclusion that the impugned judgment is unsustainable in law. It must suffer the consequence. Sri Dhruv Mehta, Learned Counsel, the submit that directions may be given to the magistrate to dispose of the application filed by the ad assistant public prosecutor under section 320 of the code for withdrawing the prosecution. On the material on record, it is not clear whether such an application has already been filed or not. Assuming that such an application is filed, then such an application will have to be dealt with by the trial court in accordance with law as interpreted by various judgments of this court in the case Abdul Karim or versus State of Karnataka, where this court has consistently let down the parameter, the duty of the law officer and the court in filing and considering such an application under section 320 of the code. Any directions for our side at this stage would only hinder an independent application of mind by the concerned court if and when such application is taken up for consideration. Therefore, without expressing any opinion on the merit of the complaint filed by the appellant, the application for withdrawal filed to be filed by the assistant public prosecutor under section 321 of the code. We think it prudent to merely quest The impugent order of the High Court leave the parties pursue their remedies available in law. Constitutions of India. Article 136 there is a delay of 680 days in preparing this petition, which has noted have above came to be filed only after criminal appeal number 964 of 2002 came up for hearing before this court. At that point of time itself, the court felt that there was an error on the part of the appellant not to have challenged the impugnant order, which error was considered as a technical error since the complaint against the accused in criminal appeal number 964 02 in the above a special leave petition was a joint complaint with with a single number 26, and what was challenged before the High Court was also single FIR, though by way of two petition even the High Court on a identical date by an identical order allow the petition causing the complaint against both the accused. In such circumstances, the Sri M.N. Krishna Mani learned senior counsel, senior counsel very strongly oppose the condonation of delay. We do not think the interest of justice would be served by refusing the condone the delay, the consequence of which would be the perpetuate and illegal order, and more so in the background of the fact when we have today quest an identical order arising from the complaint. In the said view of matter, we are we are of the opinion that the delay in filing a special leave petition should be condoned. It is order of accordingly. उसके बाद आता है एडवोकेट अजय महजीता एंड डॉक्टर कलिश चंद एडवोकेट फॉर द एपिलांट, M.N. Krishnamani senior advocate, N.M. Paul Kumar Roy and Dhruv Mehta Mohit Chaudhary advocate within for the respondent. जजमेंट में आ गया N. Santosh Haj J. The appellant is the complainant in FIR number 26 date 10/2/1998 registered with the police station Majita in Punjab. In said complaint, he alleged that the respondent hearing Jagdish Kumar and some other MS Bhalla Khati's store, and the respondent Rakesh Kumar and other of MS Binna Khad store and committed criminal act punishable under section 382, 353, 506, 186 of Indian Penal Code, herein after referring as the IPC, when the along with the staff had gone to check the stock register and quality of the goods, namely super for, phosphate sold by them phosphate sold by them. After registering the case, the concerned police authority were investigating the same. During the pendency of the investigation, the accused Jagdish Kumar and Rakesh Kumar name herein above filed two separate miscellaneous petition under section 482 of the Code of Criminal Procedure. Herein after Code of Criminal Procedures statement before a criminal petition under section 482 of Code of Criminal Procedure, herein after referred as to the court before the High Court of Punjab and Haryana and Chandigarh, when the High Court was seized of the above criminal miscellaneous petition. In both the petitions, a statement was made on behalf of the state that a decision has been taken by the government to withdraw The complaint filed in FIR number 26 dated 10-2 Nason Thalway Register at the police station Manjita, Punjab for the above said offence recording the said statement. The High Court in two identical order quashed the said FIR, gave directions to the police, the learned magistrate, not to prosecute the respective petitioner on the basis of said FIR. It is these two orders which are challenged before in above criminal appeal. Before, before we proceed to examine the correctness of the impugnated order of the High Court, it is necessary to note certain other developments that took place during the pendency of the causing petition in the High Court. On the very day the complaint was lodged in the police station, the two concerned accused sent complaint to the state government making certain allegations against the appellant, herein who was the Agriculture Development Officer Enforcement in the Department of Agriculture, Punjab State, alleging, among other things, demand of bribe and consequent harassment meted out by him them for non-payment of bribe. Bribe on the basis of the above mentioned complaint of the respondent herein the government initiated certain inquiry and based on the report received on such inquiry, the opinion of the district attorney was sought who, as per his opinion, recommended to file an application under Section 321 of the Code of Withdrawal of the Prosecution. The state also consulted additional public prosecutor who was appearing in the trial, who also recommended the withdrawal of the prosecution. It is at this stage when Section 321 application was still pending, the High Court by the impugned order quashed the proceeding, directed the police authority, the learned magistrate, not to prosecute the petitioner on basis of the above said FIR. It is also noticed from the material and order that immediately on coming to none of the recommendation made by the authority for withdrawal of the prosecution, the appellant hearing filed reply to the application opposing such withdrawal and sought for permission to prosecute to prosecute the case personally as a complaint in the event of a state government was not desiring to pursue the persecution. In view of the order of the stay granted by the High Court in the causing proceeding, the proposed framing of the charge by the trial court fixed for 25th October 2000 could not be proceeded with in view of the impugned order made by the High Court 19th October 2001 consideration and application under section 2 321 of the code by the trial court become futile. It is in this background the appellant in criminal appeal number 964 of 2002 first preferred the said appeal, which was entertained by this court after issuance of notice. Leave was granted on the 13th September 2002, Criminal Appeal number 964, obligatory which pertains only to the complaint against Jagdish Kumar was listed for hearing before this court. When this court found the technical problem is guaranteeing relief to the appellant only as against Jagdish Kumar, since the appellant had not challenged the questioning of the criminal complaint made against Rakesh Kumar in this fact situation, criminal appeal number 964 and adjourned by 6 weeks if isolated the appellant to prefer a special leave petition against the order of High Court in serial MP number 11127/03 pertaining to Rakesh Kumar also. When such a special leave petition was filed, the same was tagged along with the criminal pin number 964 of 2002. The said special leave petition is also before us today for hearing. The Learned Council, appearing for the appellant, submitted the High Court without going into the merit of the complaint that was sought to be quashed under Section 482 of the Code urged in accepting the statement made on behalf of the state government, the proceeding to quash the complaint slowly on the ground that the government had decided to drop the prosecution. He further contend that the High Court further urged in issue a direction to the police authorities and the learned magistrate not to prosecute the petitioner on the basis of the concerned FIR even before an application under Section 321 of the Code was entertained by the trial court. Therefore, the Learned Council submitted that the impugned order of passing the complaint are liable to be dismissed on the ground of non-application of mind itself. He relied upon the judgment of this court in the case of CO Nand Paswan versus State of Bihar, RISIR, to contend that in what circumstances an application under Section 321 of the Code could be allowed by the trial court and submitted that since the magistrate did not even have an opportunity of looking into such application, the High Court could not exercise such power. He also submitted that the allegation made in the complaint established the various criminal and act of respondent. Therefore, High Court would not have questioned the complaint on the basis of proposed withdrawal of the prosecution. The Learned Council also pointed out that there was some other inquiry conducted by the superior officer of the police in regard to prima facie case against the respondent. The said officer, after inquiry, had reported that the allegations made in the complaint were true. He also submitted that the opinion of the learned ad public prosecutor to withdraw the complaint is basically influenced by the desire of the higher officer of government and the reasons given by the learned additional public prosecutor for withdrawing the complaint cannot be accepted without there being trial. Sri Dhruv Mehta, Learned Counsel, appearing for the respondent accused in criminal appeal number 964/02, submitted whether the complaint filed by the appellant is motivated by co-letter consideration and the respondent accused had already made a complaint in this regard, and it is only after making proper inquiry and seeking proper legal advice the government had decided to withdraw the case hence filing of an application under section 321 before the magistrate and order thereon being only a formality. The High Court was justified in passing the impugned order based on the statement made by the learned counsel of for the state. He also submitted that if the High Court only had gone into the merit of the complaint. A plain, a plain reading of the said complaint could have the convenienced the High Court that there was absolutely no case made out the pursue the said complaint. Hence, the petitioner before the High Court was entitled to causing of the complaint on merit also. He also submitted that presuming for argument sake that the appellant has been able to point out some error in the judgment of the High Court, even then this court ipso facto would not interfere with the erroneous order of the High Court because the exercise of power under Article 136 of discretionary. It is only in case when the appellant is able to show exceptional circumstances exist in his case and the non-interference would cause grave injustice, grave injustice then alone this court could exercise its power. Article 136 of the Constitution. For this proposition, he relied on a decision of this court in Therko Khatun versus Salabin Muhammad. The Learned Council tried to point out the complaint in Vaccines was of the year 1998. There has been no progress before the trial court, and assuming that the High Court is technically wrong in causing the complaint based on the submission of the learned advocate for the state of injustice would be caused to be appellant in the fact of the present case. Therefore, on the basis of decision in Tharka Khatun B by LR Supra Wabi should refuse to exercise our discretion vested under Article 136 of the Constitution. Though we are in agreement with the ratio laid down by this court in Tharka Khatun, we do not think the fact of this case would pursued us to refuse relief sought for by the appellant. As stated above, what is pending before the High Court was a quashing petition filed under Section 482 of the Code, wherein the scope of interference the High Court is quite restricted in such a petition. In our opinion, accepting a statement made by the Counsel for the State, High Court could not have quashed the petition solely on the ground. It could only have quashed the petition if it came to the conclusion that the complaint of the appellant did not make out a tribal case against the petitioner before it. The decision of the government to withdraw the prosecution is an irrelevant ground so far as High Court is concerned to allow a petition for quashing. It is rather surprising why further directions were issued by the High Court to the police and magistrate not to prosecute the petitioner once in quest the complaint. The direction issued in the impugnant order by the High Court, in our opinion, in wholly without jurisdictions. Even under Section 482 of the Code, the High Court ought to have noticed the fact that but for the grant of stay order, there was a possibility of the trial court even framing charge against the respondent accused as far back 25th April 2000 when the case was listed for the said purpose, in which event there could have been room for argument that even a Section 32 petition would not be maintainable. Notice this error in the judgment of the High Court. Sri Dhruv Mehta, Crown Counsel, submitted that in the interest of justice, we should remand the matter back to the High Court to consider the quashing petition on merit, since according to him complaint did not make out any tribal case at all. We do not think that this prayer can be granted, since we have come to the conclusion that the impugnant judgment is unsustainable in law. It must suffer the consequence. Sri Dhruv Mehta Learned Counsel then submitted that directions may be given to the magistrate to dispose of the application filed by additional assistant public prosecutor under section 321 of the code of withdrawing the prosecution. On the material on record, it is not clear whether such an application has already been filed. Not assuming that such an application is filed, then such an application will have to be dealt with by the trial court in accordance with law, as interpreted by various judgments of this court in the case of Abdul Karim versus State of Karnataka, wherein this court has constantly let down parameter the duty of the law officer, and the court is filing and considering such an application under section 320 of the code. Any direction for our side at this stage would only hinder an independent application of mind by the concerned court if and when such application is taken up for consideration. Therefore, without expressing any opinion on the merit of the complaint filed by the appellant, the application for withdrawal be filed by Assistant Public Prosecutor under Section 321 of the Code. We think it is prudent to merely quash the impugned order of the High Court, leave the parties to pursue their remedy available in law. The appeal therefore stand allowed. Criminal Appeal number 334 of 2005. Here, learned counsel for the party. There is a delay of 680 days in preparing this petition, which, as noted above, came to be filed only after Criminal Appeal number 964 of 2002 came up for hearing before this court. At that point of time itself, the court felt that there was an error on the part of appellant not to have challenged the impugned order, which error was considered as a technical error since the complaint against the accused in Criminal Appeal number 964/02 in the above special leave petition was a joint complaint with a single number 26, and what was challenged before the High Court was also a single FIR, though by way of two petitions. Even the High Court, on the identical date by identical order, allowed the petitions quashing the complaint against both the accused. In such circumstances, though Sri M.N. Krishnamani, learned senior counsel, very strongly opposed the condonation of delay. We do not think interest of justice would be served by refusing to condone condonate the delay, the consequence of which would be perpetuate perpetuate an illegal order, more so in the background of the fact when we have today quest an identical order arising from the complaint. In the said view of the matter, we are the opinion that the delay in filing the special leave petition should be condoned and it is ordered accordingly. Leave granted. Here, learn counsel for the parties on merit. Sri N.M. Krishnamani, learned senior counsel of the respondent, herein submitted that the petitioner, herein he has no locus standi to file this appeal. Locus standi to file this appeal, we fail to see how an aggrieved complainant who was a respondent before the High Court has suffered an adverse order, which according to us can't be sustained, can be prevented from agitating his grievances by way of this appeal. Hence, we rejected this connection. The other arguments of the learned senior counsel for the respondent in this appeal being similar to be on addressed by Sri Mehta learned counsel for the respondent in the above said connected appeal. We rejected the same for the very same reason recorded herein above. For the reason stated in Criminal Appeal number 964 of 2002 and additional reason recorded in this appeal also succeeds and is allowed. अगले वीडियो में हम आपको और भी केस स्टडी को बताएंगे तो कौन कौन से केस स्टडी है। आज का वीडियो हम यहीं पर वाइप आउट कर रहे हैं। डेट्स ऑल।